Almost 6 months have passed since Canadians and people all around the world witnessed the stunning events of the G20 protests and arrests here in Toronto. But the repercussions from those few days in June are still being felt. The investigation I'm reporting on today is the first of several public attempts to get to the bottom of exactly what happened here during the week of the summit, why it happened, and what can be done to ensure it never happens again. My investigation focused on the province's role in promoting what became known as the secret security regulation, a little known and widely misunderstood legal measure that was supposed to help the police keep the peace, but in my view, wound up contributing to massive violations of civil rights. The Ministry of Community Safety and Correctional Services and the Toronto Police Service knew that the summit would pose major security challenges. When the Toronto Police asked the ministry to sponsor a special designation under the Public Works Protection Act of 1939, it was ostensibly to help them in their job, which was to protect the security fence. There were really only 3 small parts of the security perimeter that weren't already considered public works. The idea was that this new regulation would help the police close the gaps. Some people in the ministry were rightly concerned about the optics of using wartime legislation, but others saw the regulation as mere technicality. So the decision was made not to publicize it. Instead, they quietly handed the police extravagant, sweeping powers under 71-year-old law, powers that would almost certainly be illegal and unconstitutional under the Charter of Rights and Freedoms. Little did they realize that once this powerful weapon was unleashed, it would be almost impossible to control. Reviving this dormant piece of legislation, coupled with the adoption of the regulation, created a legal landscape where people were detained by the police and compelled to identify themselves, answer questions, and submit to warrantless searches, even if they simply wanted to walk away. Responsible protesters and civil rights groups who took the trouble to educate themselves about their rights prior to the G20 had no way of knowing they were literally walking into a trap. They were literally caught in the act, an act of public entrapment. The Public Works Protection Act and its pernicious regulatory offspring. En ravivant ce texte de loi poussiéreux auquel est venue s'ajouter l'adoption du règlement, les autorités ont créé un contexte légal où la police a pu interpeller les gens, les contraindre à s'identifier, à répondre à ces questions et à laisser fouiller sans mandat, même si elle préférait tout simplement s'éloigner des lieux. Les manifestants, les groupes de droit civil, qui avaient le sens des responsabilités et qui avaient pris la peine de s'informer de leurs droits avant le G5, ne pouvaient pas savoir qu'ils allaient tomber dans un traquenard. Ils se sont littéralement retrouvés au piège de la loi. Celui de la loi sur la protection des ouvrages publics et du règlement pernicieux qui en a découlé. Many of you will remember the added confusion when the Toronto Police Chief and some of his officers described the regulation as, quote, a 5-meter rule. Some of you reported about it. But there was no 5-meter rule. And even when this was corrected, police continued to arrest and search people well beyond the security zone. Our report is full of stories from people who encountered this treatment, as well as photos that capture the unforgettable scenes of those 2 days. For the first time, we used social media in our investigation to ask members of the public to come forward and to track events as they happened. People responded in droves with their stories, their photos, and their videos, including some that have never been made public until today. I also want to thank all those who came to us with precious information. Our investigation revealed some very troubling facts about the ministry's conduct in sponsoring this regulation and failing to publicize it. It was unreasonable and grossly unfair. I'm convinced that the regulation was necessary and probably illegal. I've also raised serious questions about the Public Works Protection Act, a law that no other province has. This is why my main recommendation to the ministry is that it revise and consider replacing the act, particularly in terms of the powers it confers on the police, and that it ensure that such regulations are always clearly communicated to the public in the future. I'm very pleased that the ministry has agreed to all my recommendations, and I look forward to seeing the results of the Honourable Roy McMurtry's review of the Act. As always, I will be watching closely as the ministry reports back to me on its progress. Alors que l'objectif en accueillant le sommet du G20 était de mettre en valeur le Canada aux yeux du monde, l'adoption et la mise en œuvre du règlement 233 a laissé en mémoire de tristes images et un legs regrettable que nous essayons de rectifier encore actuellement. J'espère que ce rapport et l'engagement pris par le ministère en vue d'appliquer mes recommandations contribueront à redresser la situation. Nous donnerons un plan directeur montrant comment gérer de tels événements à l'avenir. While the aim of hosting the G20 was to showcase Canada to the world, the passage and administration of Regulation 233 left ugly images and a sad legacy that we are still working to repair. I'm hopeful that this report and the ministry's commitment to implement my recommendations will help to set things right and serve as a blueprint for how to handle such events in the future.
Andre, on number 203 in your findings, you talk about an email, OPP internal email, a discussion between the OPP and the RCMP, in which it seems the OPP and the RCMP themselves are sort of taken aback by the Toronto Police conduct, that they didn't want to have anything to do with them at this point. Did the problem get that big that other law enforcement agencies were nervous about what Toronto Police were doing?
The Regulation 233, its ground zero was in Chief Blair's office. No other police agency wanted anything to do with this regulation. It was sold to the province, and the province implemented it. And many of the other law enforcement partners learned about the existence of this regulation and then the misspoken application of this regulation the very time you and I learned about it when it was reported in the media.
Monsieur Marin, vous dites que la loi a servi à intimider les gens. Pourquoi c'est intimidant et est-ce que vous pouvez donner des exemples concrets?
Écoutez, il y a des centaines de gens qui ont été détenus en vertu du règlement qui a été passé en vertu de cette loi-là. Il y a des citoyens qui tout simplement voulaient manifester, qui voulaient faire valoir leur point de vue publiquement, ce qui est permis au Canada, et qui ont tenté de vouloir connaître l'état du droit. Et puis, il était impossible de connaître l'état du droit parce que le gouvernement n'avait pas publié ce qui s'était passé et l'existence du règlement 233. I want to say there's two things about this 5-meter rule. First of all, there was the technical aspect that what is identified as 1, 2, and 3 in the map of downtown Toronto. The technical aspects of Regulation 233 was to close the loop on the fence, the infamous fence in downtown Toronto. But that, to me, was the smallest effect of that regulation. The most significant effect of Regulation 233 was that it revived a piece of wartime legislation that was passed in 1939 to protect infrastructure in Ontario from the enemies of war. And the elephant in the room at all times in the discussion of law enforcement surrounding this event is, was it really required to enact a wartime piece of legislation that gave phenomenal powers to the police and was of questionable legality.
Andre, you say that the Toronto Police Service did not cooperate with your investigation, but you obtained this email that this is 155 that Mr. Chief Blair said he didn't consult with City Hall, with City Council due to time constraints, time limits. Does that seem credible to you? That more than a month before the summit actually takes place, he's saying he hasn't had time to let Mayor David Miller or his officials know what was going on?
I couldn't comment on that. We did offer the chief 2 opportunities. I believe the letter's been distributed to you on August 5th. We wanted, first of all, the officers who were shown in various photos and video footage to come forward and explain what their understanding was of this regulation that was passed. And that was refused. The chief refused us access to those officers. And then again, subsequently on August 26th, we asked the chief to interview him because we wanted to know what his understanding was of this regulation and what instructions he passed on to the force, the Toronto Police Service. And again, we refused cooperation. You know, our role here is not like the SIU. We're not here to lay criminal charges or to investigate the criminal actions of the police. We're here to get an explanation. An explanation because this is a matter of great interest. And when the chief described this as the 5-meter rule, that bewildered you. It bewildered me. If there was any description that was more appropriate than the 5-meter rule, however erroneous, was to call it the 5-kilometer rule. Because people were in Arlen Gardens 2 kilometers away having their knapsacks examined and searched by the police. We encountered a woman who was leaving the Queen's Quay Loblaws, and she was getting her groceries examined by the police, even though she was hundreds of meters from the fence. And this happened throughout Toronto without any legal justification. You got to be clear, police can ask whatever questions they want. They can ask people, what is your name? Please identify yourself. But what we saw, and that's why we showed pictures of it. If you look at page 10 of the report, for example, we had 3 police officers stopping an individual on a bike and using the authority of the Public Works Act to force someone to identify themselves and be searched. That is illegal behavior. You can't do that. There's no legal basis for the police to do that. Unless, of course, they're relying on the Public Works Protection Act, which is wartime legislation.
That you're not there. This was all coming out. I spoke to the minister at the time, and he kept citing that there was a court decision upholding this law, a fairly recent court decision. I think it was in the 80s or the 90s. Why do you believe that this law is unconstitutional?
You know, there is case law that within reasonable limits and applied in a way that's circumscribed and meets the charter, that there are common law authority in the police to do certain things. When we produced this report to the ministry, it had its lawyers analyze it. They accepted our findings. So I'm not sure what the ministry exactly told you, but there are common law authorities where the police can, if they have reasonable grounds to believe you've committed an offense, to search you. There's common law authority to protect international dignitaries within reason. There's no common law authority that I'm aware of that entitles the police to exercise prophylactic scan detention. And that's what they were doing.
Report that you weren't there to obviously look at the instances of accusations of physical abuse, but that how do you think the misinterpretation and misunderstanding of this act might have colored, the relationship between police and protesters and everyone else out there?
No, let's be clear. The ministry at one point said, we could have done better in the communication of the regulation. Well, you're darn right, you could have done better. There was a premeditated, conscious, planned decision not to announce the existence of the regulation or the reviving of this wartime act, this relic. The government essentially poked a hibernating bear, woke it up, and they didn't want the public to know. The government, the ministry had its website. City of Toronto had a website. The Integrated Security Unit had websites. Had ads in the paper, warning about street closures, things that were going to happen. Was there any, at one point, mention that the police had a right, according to a 1939 law, to arbitrarily detain citizens kilometers away from the fence, to search their belongings, and to force them to identify themselves? No, at any time there was not, and that was a conscious, premeditated decision by the authorities. Apart from a coterie of senior officials in government and the Toronto Police Service, no one else was aware of the existence of this regulation or the fact that they would trigger what amounted to martial law in downtown Toronto.
So did they withhold facts, or did they lie to us?
They just didn't announce. They took a decision not to announce, to be reactive and not proactive, and to answer individual reporters' questions as they arose. Page 130 of the report, paragraph 130 rather, we provide further explanation that was gleaned from communications briefings given within the ministry. One final point about cooperation as well is that the ministry invokes solicitor-client privilege on the discussion between lawyers and government officials. So we're not privy to that information, but we're able to obtain information from the communication side, which allowed us to piece together that part of the puzzle.
Monsieur Marin, êtes-vous en train de dire que le gouvernement et les policiers ont berné le public durant cette fin de semaine et comment cela a contribué au chaos de toutes ces arrestations?
J'ai manqué la première partie de votre question.
Vous êtes en train de dire que les policiers et le gouvernement ont
Excuse
voulu
me, Flash
berner...
guys, I've got you back of your heads in a bunch of shots, sir.
Excusez-moi. Est-ce que vous êtes en train de dire que le gouvernement et les policiers ont voulu berner le public pour leur faire croire certaines choses durant la fin de semaine? Et comment cette loi a contribué à tout ce chaos, ces arrestations?
Je pense que le gouvernement n'a pas annoncé publiquement qu'il avait déclenché les mesures exceptionnelles qui sont dans la loi sur la protection des ouvrages publics, parce que le gouvernement avait un peu froid aux yeux. Il ne voulait pas attirer trop d'attention au fait que des mesures de guerre de 1939 avaient été déclarées dans la ville de Toronto. Et ce qui a fait que ça l'a pris en surprise le public, qui n'avait pas le moyen de savoir, les moyens ou les mesures pour savoir à quel point le public risquait d'être en état d'arrestation ou non. Donc, on a vu les résultats qui se sont ensuis.
Donc, c'était intentionnel de la part du gouvernement.
Il n'y a pas de doute, c'était intentionnel de ne pas communiquer cette information-là au public.
Wake of all, when this first came out, everyone from the premier on down strongly resisted calling this law secret. They kept telling us, again from the premier on down, it was there in the ads for all to see. You're now saying that they were deliberately not telling people in advance the detail of this. How do you characterize that? And the reaction of this when this first came out then, were those lies they were telling us or deliberate bending of the truth?
Well, there's, when a regulation is passed, there are technical elements to passing a regulation. The very strict, narrow technical requirements. In other words, it has to be permitted by legislation, which in this case, I would add, was not permitted by legislation, because the legislation is for the protection of infrastructure, yet the regulation is passed to protect people. But that's another issue. But then the regulation has to be signed by X number of ministers and then published in a certain way, and the technical requirements of the Act were met. However, the practical requirements is when you have peaceful demonstrators and civil liberties organizations that are gathering and want to know the extent of the powers that the police will be invoking to ensure the security of the G20, it seems to me those people should have been told, we will be relying on this 1939 Act. They were not told that. This Act was not publicized. It was not in any of the ads that were published. And the problem with it is that by not putting it, it didn't allow protesters to challenge the authority. You'll recall when the police announced they were going to use a noise cannon. The Canadian Civil Liberties Association challenged that in courts, and the court issued a ruling about in what circumstances that instrument could be used. Now, you couldn't do that in this case because you were not aware that the 1939 Act was going to be invoked. If that had been publicized, my suspicion was somebody would have challenged the government's right to use it.
My question is, though, even when it finally hit the papers and even when the questions were starting to be asked about it, were we even misled then in public statements?
Well, I'll let you conclude that. My conclusion today, my finding is that the government planned and premeditated not to communicate what authority it was relying on to execute searches, to arbitrarily detain citizens. And that, in my view, is problematic.
Andre, now finding number 40, you talk about the actual day on Saturday of the riots that we all kind of saw and experienced, and that there was a 45-minute black window where the ISU couldn't get a hold of Toronto police. They spent a fortune on communications. Did you find out, one, where Toronto police went during that time? And then you also allude to RCMP officers left the nation's capital bare as they trekked south to provide assistance in Toronto. How grave is that, and what's the context of that statement?
Well, it's not. This was provided because it came up during an investigation. I think it was proper narrative for us to review that in terms of providing you with a complete picture of the confusion that day. And part of the confusion that day, I think, can be drawn right down to the existence and the reliance on that 1939 piece of legislation nobody was aware of. There was mass confusion that could have been dealt with up front had authorities been clear on what enforcement mechanisms they were relying on. I mean, that particular weekend, there was a cascade effect of state mischief that resulted in hundreds of detentions. People are focusing on the 1,000 people plus arrested and brought in the specifically designated prison in Scarborough. And that's certainly a fair comment. But what about all the other people arbitrarily detained on the spot? Hundreds of them, possibly thousands, that weekend. Police do not have the right to detain people arbitrarily and force them under threat of law to identify themselves and be searched on the spot.
Iriez-vous jusqu'à dire qu'en raison de tout ce que vous avez observé, le chef de police de Toronto devrait démissionner?
C'est pas mon rôle d'offrir ce genre d'opinion.
Comment qualifiez-vous ces actions, M. Blair?
Écoutez, M. Blair n'a pas collaboré avec notre enquête, c'est ce qui est malheureux. Et puis, il y a eu toutes sortes d'informations qui sont fausses, qui ont été émises publiquement pendant la fin de semaine, qui n'ont pas aidé les choses. Et évidemment, c'était très malheureux.
Given all of this, just in English, do you think that the chief of police of Toronto should resign? And how did he cooperate with your look into this?
It's not my function to comment on individual actions, so I'll refrain from doing that. And the second part of your question was?
How much cooperation did you get from Toronto Police Service?
Zero. I mean, zero cooperation, which is rather astounding. I'm not conducting criminal investigation. I could have subpoenaed Chief Blair. The ability under my act to subpoena people and to force them to give testimony under oath. Now, fortunately, this case it was not necessary to go down that route because we had access and full cooperation by the provincial ministry, who was able to provide us the letters and communication they had with Chief Blair. So Chief Blair's participation was not required in the end. Really, we were able to get the job done without him. It's unfortunate, though, that we weren't able to interview those officers that were captured on video and still images because we wanted to know who had briefed them about their authority. But again, we found the answers to that through the ministry in the passage of a regulation under the 1939 Act.
Leslie, could you just give us a sense of what the actual authority was in reality?
Under the Act?
Under the Act and where it applied in reality. And,
Well, this is an act, I have to remember, the 1939 Act, as I said, is a relic. It's a civil rights landmine from World War II that was never repealed. It exists today. And it designates as public works, public buildings, public parks, streets, and highways. So theoretically today, the police could, on any of those areas, start saying, I'm enforcing the 1939 Public Works Protection Act. They didn't need the fence to do that. But people know very well, anyone who has a high school grade law education knows very well that the police do not or cannot arbitrarily detain people in Canada to ask for their ID. So people just ignore the 1939 Act, except here when Chief Blair petitioned the government to extend the Public Works Protection Act, these three discrete areas listed in green. Because these three areas in green did not fall within the narrow provisions of the Public Works Act. So the police wanted to feel a greater zone of comfort. This was to put the police in a comfort zone. But what happened is that it also provided the triggering of this act to then lead to the abuses which went kilometers away from this zone. So I thank you. Yes.
A law that's likely illegal, passed in secret, sounds something not normal for a democracy, to put it kindly. Was this sort of some sort of attack on our democracy, or was this some sort of some kind of madness that overtook the people in a position of power in the face of this kind of international pressure?
We have the means as a society to bring proper law and order. Many observers will tell you, legal experts, that you didn't really require any additional authority, that the common law authority and existing law was sufficient. But suppose the government disagreed. It had the option. The option was to pass a proper piece of legislation that protects people, not to rely on a 1939 piece of legislation protecting infrastructure. In the 1970s, when Prime Minister Trudeau invoked the War Measures Act, he presented it in Parliament. There was a debate. Rightly or wrongly, it passed, and it led to the arrest of just under 500 people with about 60 charges. Fast forward 2010, we bring back to life a 1939 Act that leads to the arrest of over 1,000 people with 99 charges outstanding. To me, that's disturbing. And for the citizens of Toronto, the days up to and including the weekend of the G20 will live in infamy as a time period where martial law set in the city of Toronto, leading to the most massive compromise of civil liberties in Canadian history. And we can never let that happen again. Thank you.